All right. Welcome, everybody. I am attorney Justin Randall with Hooper Law Office, and today we're going to be talking about questions that are commonly misunderstood when people are dealing with probate. Things like, hey, do I inherit my parents' debt when they pass away? Or, other common issues that we run into with people. But before I dive into any, direct details on things, I just want to say that we are going to be sending you an email with a follow-up form. It gives you a place to reach out to us if you'd like us to set aside time for an initial consultation with you. Our initial consultations are complimentary, so they don't cost you anything to come in and talk to us. We set them up for about 2 hours to give us plenty of time to go through things. So if anything we're talking about today makes you think, hey, I'd really like to come in and meet with one of the attorneys at Hooper Law Office, please feel free to fill that out, and we will. You can send it back to us, and we will know to reach out to you then. But this is also meant to be interactive. So if you have any questions that you'd like to ask as I'm going through things, maybe questions that you have that I don't cover necessarily, please submit those via the chat or Q&A function. Otherwise, keep an eye out as well if there's some more in-depth questions that you might have. We are going to be having our in-person wills versus trust seminar in Oshkosh on January 17th. There will be a 2 p.m. and a 6 p.m. session for that. Or excuse me, a 2 p.m. and a 6 p.m. session. So if you want to sign up for that, you can do that at estateplanninglive.com. So I guess to kind of start with some things here, when we're talking about really commonly misunderstood questions, especially when it comes to probate, probably one of the most common questions we get or concerns that people have are if there's substantial debt in the family or with mom and dad, or there's maybe some concerns about outstanding bills, is whether or not the children will inherit mom and dad's debt when they pass away. So the good news is that under most circumstances, you will not be inheriting parents' debt. There are a few exceptions where it's not so much that you're inheriting it just because of being a child, but there could be some other circumstances where somebody might become responsible for debt that goes unpaid. So you don't just inherit the debt. It's not just by nature of being a beneficiary. But where you can inherit debt or inherit debt in quotation marks, is potentially if you, for example, co-signed on a loan. So if you're a co-signer on the loan, you're equally responsible for it. That could mean that you are potentially responsible for someone's debt after they pass away because you also took on that debt. Where I think a lot of people run into issues potentially with debt after someone passes away is when maybe the estate is relatively straightforward from an asset standpoint. Maybe it's relatively small, and they try to file what's called a transfer by affidavit. So essentially what a transfer by affidavit is saying, well, these assets would be subject to probate, but the total amount of assets are below a certain amount of money, so that it's not really worth going through probate with these things. That amount is if the total amount of assets that would otherwise be subject to probate are under $50,000, you can use a transfer by affidavit to transfer them following the terms of the will. But when you submit one of these things, if you're the personal representative, for example, if you would have been the personal representative, you accept some responsibility to pay debts. You are the one who has to make sure that if there are any debts owed, you pay them then as the person receiving those funds. So you have to be careful when you're filing a transfer by affidavit to make sure that somebody doesn't have any outstanding debt that you just don't pay. Where I see this probably come up as a more common concern in particular is when it comes to the scenario where maybe mom or dad was in a nursing home or assisted living facility and received Medicaid assistance at some point. Well, in Wisconsin, Medicaid has a program called estate recovery, where they can come in and say, well, we paid so much for your care. So if we paid that much out, that's how much your estate owes us and how much we can recover from it. So essentially, it's a debt that has to be repaid. When you file that transfer by affidavit, a lot of times when that's happening, and I've seen specific examples of this, where the family forgets to even notify estate recovery, and then estate recovery comes back later and says, hey, What about the however much money that we were owed? We know this is how much money they had left. When are we going to get paid? So you have to be very careful with that and just make sure that you're keeping track of any bills that are owed if you're going to use that process. Now, when it comes to, I mentioned probate a couple of times here. Another really common misunderstanding that people have when it comes to probate is whether or not wills are actually subject to probate. So a lot of times people will come to us and say, well, I have a will, so why is it that I have to go through probate? Well, that's because wills are directly, or what they are is specifically instructions directly to the court through the probate process, how you want things handled, who you want in charge, where you want things to go, if there's any other sort of special planning that you're doing, right? So wills are probate tools. They don't help you avoid probate. That's where they actually have any sort of weight or authority. So if you have a will, you're basically telling people, if that's the main controlling document that you have, and you don't have, for example, a trust as well, what you're essentially telling people is use the probate process for my assets. So this can actually lead to quite a few mistakes, potentially accidental mistakes, but still mistakes, where somebody will have, only a will. They'll be essentially directing people through the probate process, but they won't have their assets actually subject to that process. So what I mean by that is, let's say somebody said, I'm going to put a transfer on death designation on my home so that it goes directly to my beneficiaries when I pass away. Well, those types of transfers, beneficiary designations, payable on death, transfer on death, they could be referenced a number of ways. Those types of transfers transfer directly from point A to point B. They skip that probate process. Now that sounds great because it simplifies the process, the transfer process anyway. But the problem is if you actually are using a will to direct your probate estate to put somebody in charge of paying bills, make sure that things go exactly how you want them to go, you actually want the money subject to that process. So if you have a will, a very common misunderstanding with that is that, well, it's going to either help me avoid probate or that somebody has to follow this, even if there's no probate. No, if you're using a will, you want certain things to be subject to the probate process. And how this sort of ties into this debt discussion of whether or not you actually inherit debt, how that process is dealt with, is if there's substantial debt that might be owed by mom or dad or the person that you're acting on behalf of their estate as a personal representative, you actually might want the probate process to take care of some of these expenses. So the reason people don't inherit their parents' debt, aside from just like public policy arguments, is when you go through probate, one of the first things that you have to do is give a notice to creditors, a direct notice to known creditors that exist. So like if you knew a bank had a mortgage, you have to tell the bank directly because you know who that is. But you also have to file a publication that says, hey, this person passed away. You have a certain time frame to come forward and file a claim against their estate. Now with probate, that's around 90 days that those creditors from the initial publication have to file a claim. If they don't file that claim in time, their claim is null and void. So unless they have some other sort of security. So where this is really helpful is you want the probate process if there's substantial debt, because it gives a place to make sure that that notice is being made, that you have things covered, that that personal representative isn't going to be personally responsible. So probate is a good tool sometimes, especially when there's substantial debt. And then probably the last myth that we run into a lot when it comes to probate is how somebody gets the authority to pay bills. So we work with a lot of people who may have been mom or dad's personal representative, or excuse me, their power of attorney. But powers of attorney authority end at death. So if you have that power of attorney authority, you can't just pay bills after mom and dad pass away. That's where you have to be nominated as a personal representative through the will. So probate, again, if that's the tool somebody has to pay bills, they're using a will, you have to be nominated and approved by the court as a personal representative in order to pay those bills. So you don't want to start trying to access things as a power of attorney after the person you're acting on behalf of has passed away. So just make sure that when we're talking about debt, that you know that there are certain processes that have to be followed to deal with debt after somebody passes away, but that you are not personally responsible for it unless you somehow accept that personal responsibility. So that is particularly where if you are filing something like a transfer by affidavit saying that, hey, the estate's small enough, we don't need to go through probate. Know that if you are the person receiving those funds, you are responsible to make sure that creditors are paid if there are any. So a discussion you always have to have is, well, how much in terms of creditors, or debt did this person actually have when they passed away? If it's very unlikely that they had any, maybe a transfer by affidavit works just fine, and you don't have to worry about accepting too much responsibility for any existing debt. However, where this doesn't seem like there might be debt, for example, but there often still is when somebody has received Medicaid assistance. So just because they don't owe any other bills to a bank, or they don't have any loans out there, they received Medicaid assistance in connection with long-term care services. So like in a facility for like skilled nursing facility, assisted living facilities, they will still have some level of debt, quote unquote, owed to Medicaid estate recovery to pay that back. Now they can't exceed the value of assets that the person actually had. So that level of debt responsibility might differ depending on how much that person still had when they passed away. If all that person had was $2,000 in assets, that's really all that they could recover against. But if, let's say, they still had their home and that home was sold and it was, transfer on death deeds were filed, and so all the people sold the home and just went about their different ways, there could be a lot more debt owed back to estate recovery if you're not careful. So just be very careful when you're filing transfer by affidavits. Generally speaking, if you're talking with an attorney who is an estate planning attorney, an elder law attorney, they can give you good advice on whether or not you have any sort of substantial risk owed to estate recovery, or risk that you're taking on when you're transferring those assets. When the debt discussion comes up a lot, thankfully, we are not in one of the states that has what are called filial responsibility laws. So essentially what that means is you owe a duty to mom and dad as a child to potentially help them pay debts, help them pay for nursing home expenses. Wisconsin is not one of those states. So they're not overly common. That, not many states actually have those rules, but the rules I'm talking about here, where you're not inheriting a parent's debt, apply to Wisconsin in particular, and likely apply to a lot of states. But if you don't live in Wisconsin, just make sure, or your parents lived outside of Wisconsin and you have questions about whether or not there's debt owed back to anybody, make sure you're talking with an attorney that's licensed in that state as well, because you are going to get varying answers on that. So I'm not seeing any questions, but just as a reminder, if you do have any questions, you can always send them in to learnmore@hooperlawoffice.com. You can send them into the chat here, of course. Or if you would like us to follow up with you, please feel free to reach out through that form we're going to send you via the email you used to sign up for this webinar. And again, our initial consultations are complimentary. They don't cost you anything to come in and talk to us. We want to make sure we're giving you good advice. And it helps us really decide, well, what would the best plan be for you, or the best course of action? Because we don't really know that until we sit down and get to talk to you. So if you would like to set up that initial consultation, you can do so through, let us know that through that feedback form that we'll give you. And quite frankly, if there's just any other topics that you're really curious about or you'd like to hear about, we're always looking for ideas on those types of webinars too. So if you have any questions that you want answered that relate to estate planning, please let us know through that. Otherwise, just one last quick reminder here that we will be having our Wills versus Trust public seminar in next week, actually, excuse me. So on January 17th, down in Oshkosh, we will be having our Wills versus Trust public seminar at 2 p.m. and 6 p.m. If you would like to sign up for that, it helps us if you do so in advance on estateplanninglive.com, or you can call our office to do that. Just helps us make sure we have a good head count. Otherwise, I hope everybody had a wonderful holiday season, and I hope to see you all down in Oshkosh